Today you're joining us as we navigate a really dynamic area, how artificial intelligence and surveillance are being addressed in the legal landscape, specifically concerning our workplaces and as consumers.
And a central point of concern that emerges in several of these bills, particularly in Colorado and Illinois, is the use of data gathered through surveillance by automated systems to determine individual pricing and even wages. Let's start there.
Okay, so kicking things off with Colorado's House Bill 1264, this piece of legislation directly targets what it calls surveillance-based price discrimination and surveillance-based wage discrimination. Can you break down what those terms actually mean in the context of this bill?
Certainly. In essence, Colorado's HB 10264 defines surveillance-based price discrimination as the practice of using an automated decision system to set different prices for consumers based on data collected through surveillance. Similarly, surveillance-based wage discrimination refers to using such a system to determine an individual worker's pay based on their surveillance data.
And what kind of information is considered surveillance data under this bill? It sounds like it could be quite broad.
You're right to notice that. Surveillance data is defined very broadly as any data that's obtained through observing, inferring, or actively surveilling a consumer or a worker. This includes data related to their personal characteristics, their behaviors, their biometric information, or even characteristics of a group they might belong to. The bill also clarifies that this includes information that is gathered directly, purchased from third parties, or, acquired in any other way.
Behaviors is another term that's specifically defined. What falls under that category?
The definition of behaviors is also quite expansive. It covers any actions, habits, preferences, interests, or even vulnerabilities of an individual that can be observed, measured, or inferred. The bill gives several examples, such as political, personal, or professional affiliations, what websites someone visits, the IP addresses they use, the places they go, their purchase history, their financial situation, and general consumer habits. It even includes inferences that might be associated with a group or category of people.
That's a really wide scope. And biometrics, when we hear that, we often think of things like fingerprints or facial recognition. Is the definition in this bill similarly limited?
Not at all. The Colorado bill has a very thorough definition of biometrics. It includes any data that comes from the technological processing, measurement, or analysis of biological, physical, or behavioral traits that can uniquely identify an individual. They specifically list things like fingerprints, voice prints, retina or iris scans, facial maps, geometry or templates, genetic information, and even other unique biological, physical, or behavioral patterns or characteristics.
It seems like this bill is trying to anticipate various ways data could be collected and used. Now, are there any situations where setting different prices or wages based on data isn't considered surveillance-based discrimination under this law? It can't be an absolute prohibition, can it?
That's correct. The bill does outline specific practices that do not fall under the definition of surveillance-based discrimination. An employer hasn't engaged in surveillance-based wage discrimination if they can demonstrate two key things. First, any individualized wages must be based solely on either data that is specific to that individual worker and directly related to the tasks they were hired to perform, or on documented differences in the actual cost to the worker of providing their labor. Second, and this is crucial for transparency, the employer must disclose, in plain language, before hiring the worker, and to all workers whose wages are set at least partially by an automated system, exactly what data is being considered and how that system uses it in its calculations.
So the focus is on making sure wage differences are tied to the actual job and its demands, or legitimate cost differences, and that workers know how their pay is being determined.
Exactly. The Colorado bill also clarifies that simply not hiring someone who doesn't have prior work history with that particular company is not considered surveillance-based wage discrimination.
Now, what happens if these prohibitions are violated? What are the consequences for businesses that engage in surveillance-based price or wage discrimination?
Violations are classified as deceptive trade practices under the Colorado Consumer Protection Act. This gives authorities the power to take enforcement action. The Attorney General or local district attorneys can bring civil lawsuits on behalf of the state. If they're successful, they can seek civil penalties of up to $10,000 for each violation. And importantly, the bill specifies that every affected consumer, worker, or individual transaction can be considered a separate violation.
Are there also ways for individuals who believe they've been discriminated against to take action themselves?
Yes. The bill establishes what's known as a private right of action. This means that individuals or groups who believe they have been harmed by a violation can file their own civil lawsuit. They can seek a court order to stop the discriminatory practices from continuing and to recover damages, as well as their legal costs, including reasonable attorney fees. The potential damages include the greater of their actual financial losses, with interest, or a statutory amount of $3,000 for each violation. And if the violation is found to have been done in bad faith or intentionally, the individual could even recover 3 times the amount of their actual damages. This private right of action could be a significant factor in the practical enforcement of this law.
It sounds like Colorado has put some real teeth into this legislation. Now let's shift our attention to Illinois Senate Bill 2255. How does their approach to this issue compare to what we've just discussed in Colorado?
Illinois' SB 2255 takes a very similar path in terms of focusing on prohibiting surveillance-based price and wage discrimination.
Are the exemptions and exceptions for price and wage discrimination also similar in the Illinois bill?
Yes, their exceptions for wage discrimination are also quite similar. They require individualized wages to be based solely on data directly related to the job tasks or legitimate differences in the cost of labor, and they also emphasize the need for clear, upfront disclosure to employees, along with a proactive requirement to have procedures in place to ensure the accuracy of the data used in these systems.
And what about how this bill is enforced in Illinois?
In Illinois, enforcement is primarily the responsibility of the Attorney General. They have the authority to pursue civil penalties of up to $10,000 per violation, as well as recover attorney's fees. Similar to Colorado, each instance of a violation is considered a separate offense. Illinois also provides a private right of action for individuals or groups who believe they have been harmed. They can seek court orders to stop the violations, recover damages, and have their legal costs, including attorney's fees, covered.
Now let's shift our focus to Maryland. Their House Bill 1331F and Senate Bill 906 seem to take a slightly different tack, focusing more on transparency and managing the risks associated with AI systems.
That's a key difference in Maryland's approach. HB 1331F specifically targets high-risk artificial intelligence systems. Instead of directly prohibiting certain uses of surveillance data, it focuses on creating obligations for the developers and deployers of these systems to be more transparent about how they work and the potential risks they might pose.
What are the developers of high-risk AI systems required to do under this Maryland bill?
Developers are required to create standardized documentation and provide it to potential purchasers of their high-risk AI systems. This documentation must clearly explain the system's purpose, its intended uses, the benefits it's supposed to provide, and the outputs it generates. Crucially, it also needs to include a description of any known and reasonably foreseeable risks of what the bill terms algorithmic discrimination. Additionally, developers are required to notify the Attorney General that this documentation exists and is available.
And what about the deployers, the entities that are actually using these high-risk AI systems? What are their responsibilities?
Deployers have a responsibility to take reasonable steps to protect consumers from the known or reasonably foreseeable risks of algorithmic discrimination that could arise from the way they intend to use the high-risk AI. They are also required to put in place a risk management policy to govern how they deploy these systems.
Are there any exceptions to these requirements for smaller businesses or for less complex uses of AI?
Yes, there are some exceptions for certain deployer obligations specifically, the requirements for a risk management policy, conducting an impact assessment, and providing certain disclosures for entities that meet specific criteria related to their size and how they use the AI. To qualify for these exemptions, a deployer must have fewer than 50 full-time equivalent employees. They must use the high-risk AI on data that they did not collect or train themselves, and they must be using the AI in the way that the developer intended, also on data that they didn't collect.
You also mentioned transparency requirements for deployers. What kind of information do they need to provide to consumers?
When deployers use a high-risk AI system to make what the bill considers consequential decisions that impact consumers, things like denying them services or charging them higher prices, they're obligated to provide explanations about the decision that was made, clearly identify the data sources that the AI used in reaching that decision, and offer the consumer an opportunity to correct any data that might be inaccurate. This information must be provided in plain language, in a format that is accessible to people with disabilities, and in every language that the deployer regularly uses in their consumer-facing materials.
So the goal is to ensure that consumers have some understanding of why they received a particular outcome and have a way to address potential errors in the data that the AI relied on.
Precisely. The Maryland bill also addresses the sensitive issue of trade secrets. It allows developers and deployers to withhold information that constitutes a trade secret or is otherwise legally protected from the Attorney General when providing the required documentation. However, any information that is provided to the Attorney General under these disclosure requirements is specifically stated to not be subject to public disclosure under Maryland's Public Information Act.
And what are the consequences for violating these rules in Maryland?
Violations are classified as unfair, abusive, or deceptive trade practices under Maryland law. This means they can be subject to enforcement and penalties by the Attorney General under the Maryland Consumer Protection Act, with one specific exception related to consent orders. However, this doesn't prevent consumers from pursuing other legal remedies that might be available to them under other laws.
Interestingly, the Maryland bill also includes provisions related to voice and likeness clones, which seems a bit outside the main focus on AI. What's the connection there?
Yes, there are new sections in the bill that address agreements concerning the creation or use of digital replicas of a person's voice or image. The bill states that any agreement to perform personal or professional services is not enforceable if it allows for the creation or use of such a digital copy to replace the live work, unless the agreement includes a very clear and easy-to-understand description of how these digital copies will be used, the terms under which they are licensed, and importantly, that the person whose voice or likeness is being cloned was represented by a lawyer or a labor union during the negotiation of the agreement.
Now let's move on to New Mexico's The AI Act, House Bill 0060. This has a very broad title. What are the core principles and focus of this act?
New Mexico's AI Act has a broad, overarching goal of preventing what it defines as algorithmic discrimination in decisions that it deems consequential.
And how does the act define those two key phrases, algorithmic discrimination and consequential decisions?
Algorithmic discrimination is defined in the Act as unlawful differential treatment or impact based on protected characteristics that results from the use of an artificial intelligence system in a consequential decision. Consequential decisions are then defined as those that have a significant material or legal effect on various aspects of an individual's life, including education enrollment, employment, access to financial services, healthcare, housing, insurance, and legal services.
So these are really the core areas where discrimination can have the most significant impact on people's lives. Does the Act differentiate between different kinds of AI systems based on their risk level?
Yes, it does. The Act distinguishes between high-risk artificial intelligence systems, which are those that make or substantially factor into these consequential decisions, and other types of technologies that might use AI but don't carry the same level of potential impact.
What kind of responsibilities or obligations does the AI Act place on the developers of these high-risk AI systems in New Mexico?
Developers are subject to a duty of care, which means they have a legal obligation to make reasonable efforts to identify, document, and take steps to mitigate any known or foreseeable risks of algorithmic discrimination before their system is deployed. They are also required to create and make available to those who will be using their system a high-level summary and more detailed documentation about how the system works. This includes its intended uses, what categories of data it relies on, how its performance is measured, and what transparency measures have been incorporated.
So there's a focus on ensuring that those using the AI have a good understanding of its capabilities and limitations. What happens if a high-risk AI system does end up causing discrimination?
The Act requires developers to disclose what it calls risk incidents, meaning instances where their system has caused algorithmic discrimination to the New Mexico State Department of Justice and to all known recipients of the system within 90 days of becoming aware of the incident. The State Department also has the authority to request copies of the summary and documentation that the developer provides to the system's users.
And what responsibilities fall on the deployers, the entities that are actually using these high-risk AI systems in New Mexico?
Deployers are required to implement a risk management policy with the goal of mitigating the risk of algorithmic discrimination arising from their use of the high-risk AI. When a high-risk AI system is used to make a consequential decision, deployers also have significant transparency obligations towards the individuals affected by that decision. They need to provide the consumer with a clear explanation of the main reasons behind the decision, the extent to which the AI system contributed to that decision, and the sources and types of data that were processed by the AI. Importantly, they must also offer the consumer an opportunity to correct any data that they believe is inaccurate. This information must be provided in plain language, in all languages that the deployer regularly uses in their consumer-facing materials, and in a format that is accessible to people with disabilities.
It sounds like New Mexico, similar to Maryland, is prioritizing transparency, but with a more direct link to preventing discriminatory outcomes. What about the enforcement of this AI Act in New Mexico?
Well, the specific penalties for violations aren't detailed in the excerpts we have, but the Act does require deployers to notify the State Department of Justice within 90 days if they discover that a high-risk AI system they are using has caused algorithmic discrimination. They are also obligated to submit their risk management policies and any impact assessments they have conducted to the Department of Justice if requested. Interestingly, the Act specifies that any risk management policies, impact assessments, and related records that are submitted to the State Department of Justice are exempt from New Mexico's public records laws. The effective date for the AI Act is July 1st, 2026.
Okay, let's now turn our attention to Virginia, which has two relevant bills. House Bill 2094, known as the High-Risk AI Developer and Deployer Act, and House Bill 2433, which specifically addresses the use of technology by law enforcement. Let's start with HB 2094. What are the key elements of Virginia's approach to regulating high-risk AI?
Virginia's HB 2094 also centers on high-risk artificial intelligence systems, defining them in a way that's similar to New Mexico's as systems that are used to make or be a substantial factor in what they term consequential decisions. The bill clarifies that substantial factor means the AI is either the primary basis for the decision or has the ability to alter the outcome. Like Maryland and New Mexico, Virginia places specific obligations on both the developers and the deployers of these high-risk AI systems.
What kind of information are developers in Virginia required to provide?
Developers in Virginia are required to provide deployers with comprehensive documentation about their high-risk AI systems. This documentation must include details about the intended uses of the AI, any reasonably foreseeable risks of algorithmic discrimination that have been identified, the categories of data that the system uses, the metrics used to evaluate its performance, and the transparency measures that have been incorporated into the system.
And what are the responsibilities of the deployers of these systems in Virginia?
Deployers are mandated to implement a risk management policy aimed at identifying, documenting, and taking steps to mitigate any risks of algorithmic discrimination that might arise from their use of the high-risk AI. They also have specific transparency requirements that kick in when a high-risk AI system is used to make a consequential decision. In those cases, they must inform consumers that a high-risk AI system was involved and provide them with a clear explanation of the decision that was made, the extent to which the AI contributed to that decision, and the data sources that the AI relied upon. This information must be provided in plain language and in formats that are accessible to individuals with disabilities.
Virginia also seems to have a unique requirement related to marking the outputs of these AI systems. Can you tell us about that?
Yes, Virginia requires both developers and deployers to mark the outputs of high-risk AI systems, particularly audio, image, and video content, to indicate that it was generated by AI.
What about the enforcement of this act and the potential penalties for violations in Virginia?
The Attorney General of Virginia has the exclusive authority to enforce this act. They are empowered to issue civil investigative demands and to seek injunctions in court to prevent ongoing violations. Entities found to be in violation are subject to civil penalties that can be up to $1,000 per violation. For willful violations, the penalties can range from $1,000 to $10,000 per violation. Any penalties collected are paid into the state's literary fund. It's important to note that the Virginia Act specifically states that it does not create a private cause of action, meaning individuals cannot directly sue for violations. The Attorney General is also required to consider whether a violation can be corrected before taking any enforcement action. The effective date for this act is July 1st, 2026.
Now let's move on to Virginia HB 2433, which focuses specifically on law enforcement's use of technology. It's interesting that Virginia has chosen to address this in a separate piece of legislation. What are the key provisions here?
This bill makes amendments to existing Virginia law concerning law enforcement and introduces new sections that specifically relate to the use of various technologies. It provides definitions for generative artificial intelligence, AI system, and machine learning system. A significant provision mandates that the Criminal Justice Services Board must establish compulsory minimum training standards for all law enforcement officers who operate or have access to audiovisual surveillance technologies.
So the aim is to ensure that officers are properly trained in the ethical and legal use of these surveillance tools.
Exactly.
Now, finally, let's turn our attention to Washington State, with House Bill 1672, which concerns the use of technology by employers, and Senate Bill 5422, which relates to collective bargaining in higher education and its intersection with AI. Let's start with HB 1672, as it seems very focused on the workplace.
Yes. Washington HB 1C72 is specifically about the use of electronic monitoring and automated decision systems in the workplace. It establishes quite strict limitations on electronic monitoring, permitting it only for specific, justifiable purposes, such as assisting with job functions, monitoring production or quality, ensuring compliance with legal requirements, protecting the health, safety, or security of employees, or tracking time or output for the purpose of compensation. Even when permitted, it must be necessary for the stated purpose, use the least invasive means possible, involve the smallest number of employees and the least amount of data, and have restricted access and use protocols.
The requirements for notifying employees about electronic monitoring sound particularly detailed.
They are indeed. Employers are required to provide employees with at least 15 calendar days advance notice before initiating any form of electronic monitoring. This notice must include a comprehensive range of information, such as the specific form of monitoring that will be used, its exact purpose, how the collected data will be used, the types of technologies involved, whether the data will be used to make employment-related decisions, who will have access to the data, how frequently the monitoring will occur, the period for which the data will be retained, how employees can access data related to them and correct any inaccuracies, and a clear statement of the employee's rights under this new law. This notice must be written in plain language and in the employee's primary language, and employers are required to provide updated notices if there are any significant changes to the monitoring practices. There's a very narrow exception to the prior notice requirement if the employer has a reasonable belief of illegal conduct, a violation of the employer's or another employee's rights, or the existence of a hostile work environment, and if the monitoring is likely to produce evidence related to that belief. Additionally, employers who use electronic monitoring are required to annually provide each employee with a list of all electronic monitoring systems that are currently in use in relation to that specific employee.
And are there also specific prohibitions on certain types of electronic monitoring in the workplace under this bill?
Absolutely. The law prohibits electronic monitoring from being used in ways that violate state or federal labor laws, for monitoring employees when they are off duty and not engaged in work-related activities, for the purpose of identifying employees who are exercising their legal rights, for audio or video monitoring in private areas such as bathrooms or break rooms, for tracking the frequency with which employees use those private areas, or for audio or video monitoring in an employee's residence or personal vehicle unless it's directly related to the employee's health, safety, or security, or to verify employer or client data security.
The bill also addresses the use of automated decision systems in the workplace. What kind of limitations or requirements are put in place there?
Employers are prohibited from using automated decision systems in ways that violate any federal, state, or local law that make predictions about an employee's performance or conduct that are not directly related to their job functions, that are used to identify, profile, or predict an employee's actual or perceived exercise of their legal rights, that are used to infer or predict an employee's emotions or personality, or that make unlawful use of customer data. Before implementing an automated decision system that could impact employment decisions, employers are required to create a detailed written impact assessment. This assessment must describe the specific automated decision system being used, the categories of data it processes, the outputs it generates, the rationale behind its use, and a thorough assessment of potential risks, including the risks of errors, algorithmic discrimination, violations of employees' legal rights, harm to employee well-being or privacy, and negative economic impacts. Employers are also required to implement reasonable security procedures to protect the confidentiality, integrity, and availability of any data produced or utilized by their electronic monitoring or automated decision systems. Furthermore, employers must provide employees, upon their request, with any data related to that employee that was produced or utilized by these systems. Finally, the law explicitly prohibits employers from retaliating against any employee for exercising their rights under this chapter.
What's the process for enforcing this workplace technology bill in Washington state?
Employees who believe their employer has violated these provisions can file a complaint with the Washington State Department of Labor and Industries. The department is then responsible for investigating these complaints. If they find a violation has occurred, they have the authority to issue citations and impose penalties on the employer. The department can also pursue enforcement of the law by filing actions in Superior Court, and if they prevail in such a lawsuit, they are entitled to recover their attorney's fees and costs. The majority of these sections of the bill are set to take effect on July 1st, 2026.
Finally, let's briefly discuss Washington Senate Bill 5422, which deals with collective bargaining in higher education. How does the use of AI factor into this legislation?
SB 5422 amends the state's collective bargaining laws specifically as they apply to institutions of higher education and other state agencies in relation to the use of artificial intelligence technology. It mandates that these public employers must engage in collective bargaining with their employees' unions over the decision to adopt or make significant changes to the use of AI technology if that use has an impact on the employees' wages, hours, or other terms and conditions of their employment. The bill defines artificial intelligence in this context as the use of machine learning and related technologies to perform tasks that are typically associated with human intelligence. It clarifies that while public employers retain their existing management rights regarding technology in general, those rights are now subject to this new bargaining requirement, specifically when it comes to the impact of AI on employment terms. However, any collective bargaining agreements that are already in effect prior to the effective date of this section of the law will remain unchanged until they expire, are up for renewal, or are formally reopened for negotiation.
So this bill essentially gives unions in higher education and other state agencies the right to negotiate with their employers about how AI is implemented in the workplace if it affects their members' jobs and working conditions.
Exactly. It recognizes that the introduction of AI into the workplace is not just a technological change, but also has significant implications for the workforce that need to be addressed through the process of collective bargaining.
As we've taken this deep dive into the legislation across these different states, what are some of the overarching key takeaways that really stand out?
What we're seeing is a very clear and growing trend towards the regulation of both artificial intelligence and various forms of surveillance, but the specific approaches that different states are taking are quite diverse. There's a strong and consistent emphasis on the importance of transparency, particularly when it comes to how AI is being used to make decisions that can significantly affect both consumers and employees. The prevention of algorithmic discrimination based on protected characteristics is another theme that appears repeatedly across these bills. Many states are also recognizing the necessity of implementing risk management frameworks and conducting impact assessments before deploying AI systems, especially those deemed to be high risk. We're also observing an evolution in how key terms like AI, surveillance data, and algorithmic discrimination are being defined as lawmakers attempt to keep pace with the rapid advancements in technology. It's evident that the potential implications of AI in both consumer and employment contexts are major areas of concern, and we're seeing the development of various enforcement mechanisms, including civil penalties and, in some cases, the creation of private rights of action for individuals. Additionally, there's specific attention being paid to the use of AI in sensitive sectors such as education and law enforcement, and the intersection of AI regulation with existing labor laws and collective bargaining agreements is beginning to be addressed in some states.
So while there isn't a uniform approach across the country, there are definitely some common threads and shared concerns emerging as states grapple with these powerful technologies.
Precisely. Each state is navigating this in a way that reflects its own priorities and existing legal framework. But the fundamental questions around fairness, transparency, and accountability in the age of AI are clearly top of mind for lawmakers across the board.